Hi everyone, welcome to Legal Talks by Desi Kanoon. I am Suyash and I am excited to have started this show. On today's show, we will discuss the case of Sanjay Ramdas Patil versus Sanjay and others, wherein the Hon'ble Supreme Court discussed the doctrine of harmonious construction. In short, doctrine of harmonious construction means that when there are two conflicting and irreconcilable provisions in a law, they should be so interpreted that, if possible, effect should be given to both. The facts of the case are not relevant for our discussion, as we would be simply discussing the doctrine of harmonious construction. Thus, let us understand the pertinent observations by the Supreme Court. Firstly, the court noted that if there are legal provisions that are capable of being interpreted in a manner that may lead to inconsistencies or conflicts, then aid of principles of interpretation may be taken. Secondly, the court cited the case of Philips India Limited versus Labour Court Madras, wherein it was held that no canon of statutory construction is more firmly established than that the statute must be read as a whole. And the only recognized exception to this well-laid principle is that it cannot be called in aid to alter the meaning of what is of itself clear and explicit. Thirdly, the court cited the case of Mohan Kumar Singhania versus Union of India, wherein it was held that when the language is clear and explicit and the words used are plain and unambiguous, we are bound to construe them in their ordinary sense with reference to other clauses of the Act or rules, as the case may be, so far as possible, to make a consistent enactment of the whole statute. Fourthly, the court cited the case of Sultana Begum versus Premchand Jain, wherein 5 important principles relating to harmonious construction were laid down. 1. It is the duty of the courts to construe the provisions which appear to be in conflict with each other in such a manner as to harmonize them. 2. The provisions of one section of a statute cannot be used to defeat the other provisions unless the court, in spite of its efforts, finds it impossible to effect reconciliation between them. 3. When there are two conflicting provisions in an act which cannot be reconciled with each other, they should be so interpreted that, if possible, effect should be given to both. 4. An interpretation which reduces one of the provisions as a dead letter or useless lumber is not harmonious construction. 5. To harmonize is not to destroy any statutory provision or to render it odious. Fifthly, the court cited the case of Commissioner of Income Tax versus Hindustan Bulk Carriers, wherein it was observed that the courts will have to reject that construction which will defeat the plain intention of the legislature, even though there may be some inexactitude in the language used. Sixthly, the court explained that when there is a choice between two possible interpretations, then the interpretation or construction that furthers the object of the statute or the law should be favored. Seventhly, according to the court, intention of the legislature must be gathered while construing a legal provision, as such manner of construction would help in avoiding any inconsistency or repugnancy either within a section or between two different sections or provisions of the same statute. Eighthly, the court noted that a construction that reduces one of the provisions to a useless lumber or dead letter is not a harmonized construction. Ninthly, the court further observed that if more than one construction is possible, that which preserves its workability and efficacy is to be preferred to the one which would render it odious or sterile. And lastly, it was observed that it is the court's duty to make what it can of the statute, knowing that the statutes are meant to be operative and not inept, and that nothing short of impossibility should allow a court to declare a statute unworkable. Thus, I hope that the meaning of Doctrine of Harmonious Construction is clear by now. The Latin maxims that explain this doctrine are ut res magis veliat quam periat and exposition ex viceribus actus. Hence, I hope you enjoyed listening to the show. Thank you for listening. Please do not forget to like and subscribe us. And if you have any comments, please make them in the comments section. See you next time. Till then, stay tuned.